Thank you, Madam Speaker. Honourable Senators, I rise to speak as the critic, albeit a friendly one, to Bill S-249. I'd like to once again thank Senator Manning for his commitment to advancing this bill for the purpose of redressing the pandemic of violence against women and intimate partner violence in this country. I also want to thank you, colleagues. S-249 is an important bill, but so is S-230, and I want to thank you for, in addition to considering this bill, we will be completing debate and having a third reading vote on S-230 on December 10th. Georgina's and Tona's laws are linked in fundamental ways. Tona was criminalized as a result of her attempts to escape violence and incestuous rape. To escape violence. So this bill is aimed at more prevention. I also want to thank so many millions of women whose experiences directly inform mine and your understanding of the urgent need to address these issues. I extend a special gratitude to the many women and girls, including Georgina McGrath, for the incredible courage and strength in sharing experiences and insisting that we all shed light on the shamefully pervasive, yet often hidden, terror visited and blamed on the women who are most victimized. These realities are the horrific backdrop to this legislation. Ms. McGrath's tenacious advocacy was instrumental in inspiring Senator Manning to develop this bill, and therefore reminds us all of the importance of demanding meaningful action to prevent and redress the circumstances that exacerbate and give rise to patriarchal and misogynist violence and abuse. As amended by the Social Affairs Committee, Bill 249 calls upon the federal government, through regular engagement with a variety of groups, federal ministers, representatives of provincial and territorial governments, Indigenous peoples, as well as victims, survivors, and other stakeholders, to continue to lead action to prevent and address intimate partner violence. We know that intimate partner violence impacts people of all genders, ages, socioeconomic, racial, educational, ethnic, religious, and cultural backgrounds. We also know, however, that women account for the vast majority of people who experience this form of gender-based violence, and that it is most often perpetrated by men. Senator Manning quoted the words of former UN Secretary General Kofi Annan, and I don't need to reiterate, but I think I would add that in addition to the fact that violence knows no boundaries, geography, culture, or wealth, I would add, however, that it certainly remains most denied, and perpetrators are less likely to be held accountable for their behavior when they hold positions of privilege and power. Just look at the realities unfolding around the world, including the recent election of a known sexually abusive predator to the presidency of the United States. For too long, we have talked about the need to redress violence against women and intimate partner violence without adequate action. The unprecedented, spine-chilling, and emboldened message that the U.S. election sends to both victims and especially to perpetrators cannot be ignored. For decades, the reflexive response has been to create harsher and longer punishments for those convicted of violence. These measures have not kept women safe. Barely any cases are ever reported. Even fewer result in charges, let alone convictions. Those who are convicted are usually those easiest to catch, people who are marginalized by poverty, race, disability, or their own previous experiences of violence, like Tona. When they have served their time, taken responsibility for their actions, and are ready to contribute positively to their communities, they are not granted the opportunities for relief from the stigma of a criminal record that measures like Bill S-212 could offer, largely due to the types of tough-on-crime rhetoric that the next U.S. president has espoused. That he has done so despite his own criminal conviction for hiding payments made to gag a sex worker, despite having been found civilly liable by a jury for sexual abuse, and despite bragging repeatedly about committing sexual assault, This all reinforces the travesty that we must act together to challenge. Too many men, especially those who are rich, powerful, and privileged, are able to prey on women with seeming impunity. We should be horrified but not surprised that trending on social media in the hours following the election was this phrase, "Your body, my choice," among other misogynist threats of forced pregnancy and rape. Nor should we be surprised that the white nationalist podcaster who appears to claim credit for this phrase, going viral, previously was welcomed as a dinner guest by the incoming president. Other popular messages online include calls for women to get back to the kitchen and for repeal of the 19th, referring to the amendment to the U.S. Constitution that protects the rights of women to vote. Exit polls, incidentally, suggest that votes cast by men preferred the next U.S. president by 13%. Women, especially young, Black, and Latino women, voted against him by a margin of 8%. Among those who swung most in his favor compared to the last election were men under 34. The demographic also most likely to follow influencers and podcasters promoting violent messages targeting women. In recent days, the use of these messages with the goal of dominating, silencing, and punishing women and girls has moved beyond the online world and particularly into schools. The Institute of Strategic Dialogue has catalogued reports of young boys in classrooms chanting, "Your body, my choice," to the girls in their schools. Harassment on university campuses has also ramped up, and groups of men in MAGA gear are reportedly telling women students to go home where they belong. November 25th was the International Day for the Elimination of Violence Against Women. On December 6, Canada will mark the 35th anniversary of the massacre at the École Polytechnique. 14 women killed simply because they were women in an engineering classroom. The urgency of working together to ensure that women are safe at home, at school, at work, and in the community has never been more clear. As girls and women faced harassment at school this month, the next U.S. president was attempting to appoint as his Attorney General the head of his Department of Justice, his chief legal advisor, and his chief law enforcement officer, a man who was investigated by that very same Department of Justice and by his colleagues in Congress in connection with child sex trafficking. The Department of Justice declined to charge him, including for reasons that will be all too familiar for victims and survivors of violence, their allies and their advocates. Authorities were concerned about whether a jury would believe the testimony of a then 17-year-old child, now a young woman, who had accused him. The congressional investigation was blocked when the would-be Attorney General resigned from Congress before a final report on his conduct could be published. Testimony to the congressional committee carrying out the investigation suggested, however, that he had paid a child for sex. While this man was ultimately unable to garner support from enough senators to confirm his appointment, at least one remaining would-be cabinet member, the nominee for Secretary of Defense, was also investigated by police in connection with sexual violence. Ultimately, he was not charged and made a settlement payment to the complainant, who is now subject to a non-disclosure agreement. We are witnessing a rise of political actors that at best are complicit in, and worst, promote harassment and violence against women and intimate partners for political gain. In this climate, men, including in this chamber, the other place, and beyond, must step up, redouble efforts, and model the behavior needed from our leaders, our role models, in order to uphold equality for all. This includes more insidious forms of sexism and misogyny, many of which are baked into the ways in which our institutions operate. Not just overt acts of violence, but the more difficult to discern and too often more hidden forms of coercion and control. As Kofi Annan reminded us, as long as violence against women continues, quote, we cannot claim to be making real progress towards equality, development, and peace. A new report from UN Women on Global Femicide has emphasized that of 85,000 women known to have been killed by men in 2023 alone, 60% were killed by a partner or family member. The report concluded that for women, the most dangerous place to be is home. This year, the story of Giselle Pellicot reminded people around the world of this truth and of the collusion by others that keep women at risk. Dominique Pellicot had admitted to raping his spouse, a 72-year-old grandmother and former business manager from France, and organizing her rape by others while she was unconscious in their home, taking thousands of photos and videos to document her repeated sexual assault over a period of 10 years. 50 men stand trial for participating in this horrendous number of rapes. Most have tried to claim, imagine, that they believed Ms. Pellicot had consented despite being unconscious, or that they were participating in a so-called sex game. Not one of the dozens who Mr. Pellicot invited to his home for this purpose appear to have notified authorities or taken any other steps to prevent these violent acts. Ms. Pellicot has garnered strong and heartfelt support from women around the world for courageously waiving her right to privacy and anonymity and insisting on public court hearings. Her goal has been to flip the script on victim blaming and insist on changes to societal condoning of rape culture and the perception that sexual violence is committed by someone else, not spouses, friends, and neighbors, and sometimes colleagues. So what must we do? As media and expert commentators have underscored, legislative efforts aimed at redressing intimate partner violence have fallen short, amounting in practice to nothing more than mere symbolism of our desire to combat violence against women in this country. Criminal law measures based on ever more punitive and mandatory sentencing laws, absent crucial funding, infrastructure, and resources to prevent, respond to, and otherwise address violence amounts to little more than lip service. Worse yet, when women and girls witness men getting away with abusive and bullying behavior, they are not likely to be inspired to have faith that they will be believed or supported if they try to call out abusive behavior. Indeed, following her August 2022 study for the British Columbia Human Rights Commission, Myrna Dawson labeled the social change impact of existing laws as weak. Honourable Senators, if Bill S-249 is to do anything more than raise awareness, we must hold each other and all governments to account and insist on the implementation of proactive, systemic, and sustainable long-term measures to combat inequality and injustice. Proactive measures must address the root causes of intimate partner violence and the inequality that underpins and reinforces existing power and socioeconomic structures and systems within which we operate. These are the factors that are most detrimental, all too often fatal, for women, all the more so if they also belong to intersectional marginalized populations, namely Indigenous women, Black women, others who are racially marginalized, as well as those living in poverty with disabilities, members of the 2S LGBTQIA+ communities, or who are otherwise oppressed primarily through the use and abuse of power by men. As journalist Dean Beebe underscores in his books regarding the Mass Casualty Commission and femicides in Renfrew County, and I quote, "Intimate partner femicides were long ago shown to be one of the few crimes that are predictable and preventable. We have a responsibility to implement measures aimed at preventing women who are abused from being subjected to rapes, assaults, and death. To understand just how usual and entrenched the threat of male violence is in the collective experience of women, one need only scan social media. The threats witnessed in the wake of the U.S. election brought to mind a viral debate on TikTok from last spring as the Senate Social Affairs Committee began its study of Bill S-249. Women responded to the question whether they'd rather be left alone in the woods with a man or a bear. Most chose the bear. Many chimed in with jarring arguments to the effect of, the worst thing the bear can do is kill me. At least people would believe me if I said I was attacked by a bear. And no one would ask me what I was wearing. These types of responses reveal what too many women experience, the dehumanizing, costly, and psychologically irreparable effects of sexualized violence. What's more, several men's reactions exhibited their rather tone-deaf ignorance, privilege, and confusion at women's responses. Some took offense and retaliated. It was particularly chilling to read responses that not only utterly failed to comprehend just how pervasive physical and sexual violence is in the lived experiences of women, but piled on with their own threats. We must end the experience by women of such threats to their day-to-day lives and decisions. This dichotomy underscores the need to dismantle the pillars of patriarchy, privilege, and power that have long served to perpetuate and maintain the subordinate social standing of women to that of men in our country and around the world. In 1993, now more than 30 years ago, the National Action Committee on the Status of Women, NAC, the largest national feminist organization of its time, comprised of over 700 affiliated groups, formulated the 99 federal steps to end violence against women. The committee recognized that violence against women is fundamentally and inextricably rooted in women's substantive inequality. Their strategy recognized that, and I quote, "Poor women, women with disabilities, women of color, and Indigenous women are more likely to be victims of assault. We seem to have difficulty with seeing the advantage men have over these women and how those legal, social, and economic advantages become part of the weaponry of violent attacks. Every kind of entrenched advantage, whether because he is of the dominant race or because he is a professional, is too often used to harm women. No program to end violence against women can be effective if it does not disrupt and transform those power relations towards equality," end quote. Indeed, has been acknowledged and reaffirmed in several reports in the decades since, including the National Action Plan to End Gender-Based Violence, the National Inquiry into Missing and Murdered Indigenous Women, the 2019 report of the United Nations Special Rapporteur on Violence Against Women, Its Causes and Consequences, and the 2022 report of the United Nations Special Rapporteur on Violence Against Indigenous Women and Girls. And they've concluded, ending partner violence requires its contextualization within broader social and economic systems and structures. This includes collaboration across sectors, legal, social, and economic, to dismantle the patriarchal norms that disadvantage women and prevent them from achieving the same level of legal protection, social standing, and financial stability as those afforded to men. Why do so many feminists bang on about the need for guaranteed livable income? Like this one. Economic disadvantage is rife. Women earn on average 89 cents for every dollar made by their male counterparts, with an even larger gap experienced by women who face compounding barriers to reaching substantive equality on the basis of their intersecting identities, particularly Indigenous women, other racially marginalized women, and women with disabilities. More than 1.5 million women in Canada are living in poverty, and 10 times more women than men have fallen out of the workforce since 2020. More women than men in Canada are experiencing financially vulnerable and precarious positions, a troubling finding alone, but even more so in the context of the detrimental financial consequences often experienced by survivors of intimate partner violence. A 2012 study reported that over 80% of the costs of intimate partner violence in Canada, an estimated $6 billion per year, are borne by survivors themselves in the forms of medical expenses, lost wages, lost education, stolen or damaged property, and pain and suffering. According to a 2021 study by the Canadian Centre for Women's Employment, 80% of the survivors of intimate partner violence in the National Capital Region alone reported that their partner displayed more controlling and coercive behaviours related to their finances and economic stability during the pandemic, and 1 in 10 were driven back under the control of their abusers due to financial dependence constraints. The ability to escape abuse is a privilege that poverty too often does not afford. In the 1970s, Manitoba's basic annual income experience led to 17.5% reduction in crime, including 350 fewer violent crimes per 100,000 people compared to similar towns. Researchers attributed this reduction to the fact that income reduced financial stress, which decreased the likelihood of a violent incident, and also improved the bargaining power and the empowerment of women, in turn reducing the incidence of partner assault. Recent research echoes these findings. Cash transfers sent directly to women can help address gender inequalities and empower women and girls by enhancing their bargaining position, their mobility, and economic and social status, thereby reducing the risks of intimate partner violence. Guaranteed livable basic income can also support women and other marginalized individuals fleeing abusive situations by providing the necessary financial resources to secure safe housing and food for themselves and their children. Facts like these reveal precisely why the National Inquiry into Missing and Murdered Indigenous Women and Girls Calls for Justice 4.5 and 16.20 were for national guaranteed livable income, and why the Federal Ombudsman for Victims of Crime recently testified to the National Finance Committee that, and I quote, "There's a whole science of crime prevention that would align with the principles of guaranteed livable income," end quote. As Professor Isabel Grant testified before the Mass Casualty Commission, economic self-sufficiency for every woman in this country is a vital part of facilitating women's abilities to escape both physical and sexual violence. If Bill S-249 is to have a positive impact on women's liberation, it must not merely acknowledge but redress the inadequacies of existing social and economic supports, ensure truly accessible and effective health care, safe and adequate housing options, food security, and universal child care. As Senator Manning reminded us of the stats, and I won't go through them again, women are often condemned for what is characterized as their choice to stay. The stats tell us completely the opposite story. Women don't choose to stay in abusive relationships. Instead, though, why don't we demand to know why the men won't let women go? Or a meaningful examination of exactly where and how we suggest they go? As Ms. McGrath and several other witnesses emphasized at committee, women experiencing intimate partner violence are expected to bear the burden of locating a safe haven for themselves and their children, as well as gaining financial independence free of influence or control from their abusive partners. All of this despite the lack of supportive attitudes, much less infrastructure to assist them in getting there. Some organizations and service providers whose efforts are dedicated to redressing violence against women have implemented response measures with women's well-being and convenience in mind. We've heard about some from Senator Kingston and others, and such approaches as Indigenous women's circles, as well as the Women Act of Toronto's Safe at Home housing model, where women fleeing violence are enabled to remain safely in their home, their existing home, or move directly to independent housing while the perpetrator is removed from the home and the risk of harm to a woman and children is effectively reduced. We must ensure that strategies are sustainable, long-term, and prioritize the safety and well-being of women. Women should not continue to be forced to endure additional hardship as a result of their efforts to escape violence and abuse. With this in mind, I want to acknowledge the work of Senator Manning and the Social Affairs Committee to heed the concerns raised by several witnesses and delete provisions of the bill that would have required engagement with respect to requirements for health professionals to make a report to the police if they suspect that a patient is a victim of intimate partner violence. As we have heard, implementing a duty to report can unintentionally hinder access to necessary support and health care for those experiencing intimate partner violence. Survivors of IPV access their health care providers and places of worship more than any other services in their communities. And it is in these settings that many survivors are most likely to build rapport and foster relationships that reach the stage of comfort that enables and empowers them to disclose their circumstances. A duty to report without requisite supports and education could actually unintentionally deter some from accessing these spaces and services altogether. Due to the long-standing effects of colonialism, racism, and patriarchy, which are embedded in the operations of our social institutions, including the healthcare system and policing forces and corrections and so many other components, Black and Indigenous women have received even less protection, respect, and care than their non-racially marginalized counterparts, let alone men. It is imperative to note that only an estimated 1 in 10 cases of intimate partner violence are even reported in the first place. If we are to encourage survivors to report and to seek help, they must be confident that adequate social, financial, and legal supports are available to them. Canada's disturbing history of violence against Indigenous women in particular contributes to their having to commonly confront racist, sexist, and other discriminatory attitudes in their encounters with institutions. The MMIWG includes far too many accounts of dismissive and combative encounters with police following experiences of gender-based violence. Many witnesses at the National Inquiry said that they no longer felt safe to reach out to police when they were in danger, fearing that the police themselves might also inflict further violence. These experiences of violence, predation with impunity, were a chief contributor to the reluctance of Indigenous women, girls, and 2S LGBTQIA+ people to trust institutions following their encounters. Not only are Indigenous women continually dismissed when they report violence, but they are also often portrayed as the aggressors, treated as if the violence is their own fault, and seen as less worthy victims by many, starting with the police and working through sometimes their lawyers, judges, the entire criminal legal system. The harassment and violence at the hands of legal authorities with which Indigenous peoples are all too familiar, coupled with the disregard, hyper-responsibilization, and deputization experienced by Indigenous women and girls when reporting their experiences of gender-based violence, results in their reluctance to report at all to anyone, end quote. Equally as troubling as their lack of response to Indigenous women's experiences of gender-based violence is the too often punitive response of legal authorities to and criminalization of women like Tona who rise to their deputization by trying to protect themselves or others from abuse. As expressed by the National Inquiry into Missing and Murdered Indigenous Women and Girls, the Canadian legal system criminalizes acts that are a direct result of survival for many Indigenous women. This entrenches and exacerbates colonialism by blaming and responsibilizing Indigenous women and their choices, while simultaneously ignoring the systemic injustices that they experience, which often lead them to commit crimes, end quote. The recent periodic review of Canada by the UN Committee on the Elimination of Discrimination Against Women has noted concerns about overrepresentation of Indigenous women in prisons. The committee highlighted as well the criminalization of the actions of Indigenous women human rights defenders. It should be noted that the expansion of Section 34 of the Criminal Code, the provision that permits the use of self-defense, was enacted under the Harper government in 2012, not for the purpose of protecting women, but for the purposes of providing property owners with the legal strength to protect their land with the necessary use of force to the extent and amount deemed reasonable. The former Prime Minister's justification for this expansion was not the protection of women forced to use lethal force to defend themselves and their children. Rather, it was to privilege property owners. The expansion of self-defense was not aimed at assisting survivors of gender-based violence. The National Inquiry into Missing and Murdered Indigenous Women and Girls revealed that Indigenous women are too often criminalized and imprisoned in response to violence being perpetrated against them or others for whom they are responsible, and that the incarceration rates of Indigenous women continue to skyrocket. In 2018, for example, Statistics Canada documented that 50% of those who reported being victims of intimate partner violence were charged themselves. Self-defense has been inconsistently applied by the Canadian legal system to survivors of gender-based violence. Rather than problematizing the unreasonable violence inflicted upon women, our legal system is notorious for instead problematizing women's reasonable responses to unreasonable and unlawful violence. Rather than perceiving a woman's use of force to combat her perpetrator's violence as reasonable, our legal system often attempts to justify her force by characterizing it as a symptom of battered women syndrome, effectively pathologizing women for attempting to protect themselves and others from harm. The Legal Committee recently witnessed the impact of the discriminatory systemic biases against women in the criminal legal system as part of its review of Bill C-40. We heard clear and cogent evidence, especially from Indigenous women like Rihanna Worm, about the inability of even seasoned and well-respected criminal lawyers to contextualize the violence experienced by women, especially Indigenous women. Worse yet, even when such context is subsequently identified, most men are unwilling to own their previous failures. Think of what that behavior models for others. It is no wonder, therefore, that despite the reality that most women convicted of violent offences are criminalised and imprisoned for their responses to violence perpetrated against them or someone in their care, to date, the current conviction review process has not resulted in a single conviction review remedy for a woman, much less an Indigenous woman. As Senator Manning has previously noted, those unfamiliar with power dynamics and the element of control that underpin perpetuation of gender-based violence may similarly be unfamiliar with the legal, social, and economic constraints posed to survivors born of racism, immigration insecurity, and poverty. As a result, they may be especially ill-equipped to appreciate the negative ramifications of an attempt to escape abuse. Survivors without the financial means to live on their own or who fear the response they will receive from the legal system and broader society cannot be said to have unqualified choice to leave their abusive partners, leaving them with no option but to retaliate against the abuse they are experiencing with physical force instead. Legal authorities at all stages of a survivor's experience with the system must respond to her report and conduct from a trauma-informed lens, with an educated understanding of the complexity of her situation as a whole. To make reporting a safe and trusted option for survivors will entail that the federal government invests in long-term sustainable measures and infrastructures that support the ability of survivors to access adequate safety plans, including financial stability, safe long-term housing, and accessible social support services. We must ensure that the environment they are seeking is safe, or at the very least safer than the environment they are escaping. The impact of Bill S-249 should be measured in terms of the real consequences this bill will have for the victims and survivors it is intended to serve. Progress on redressing and preventing intimate partner violence can only be realized with a society-wide response, supported by epidemic-level funding for gender-based violence prevention and interventions. These measures must be aimed at uprooting and unrooting the legal, social, and financial disadvantages that have maintained men's advantage and control over women in our country and which have effectively barred women from achieving the substantive equality that they deserve. A national strategy must also equip survivors, service providers, and society at large with the education necessary to access response measures available to those experiencing violence, providing them with the direction and support to safely reach shelters, access health care, build financial stability independent of their partner, and develop a life free from abuse for themselves and anyone for whom they are responsible. Let us be clear, colleagues. Perpetrators of intimate partner violence and abuse against women are not social outliers. Rather, they are examples of an extreme and all too frequent outcome of the patriarchal and misogynist social norms and structures in which they and we are raised. Structures that focus on the exertion of dominance over women and which enable abuse without consequence. Over 30 years ago, women's groups recognized that ending violence against women required disrupting the power relations that maintain women's subordinate social standing compared to that of men. Today, especially the consequences of the U.S. election, continue to ripple through Canadian politics. This legislation should compel us as decision makers to face that still unmet challenge. 30 years from now, hopefully our successors will look back at this moment as the beginning of a monumental shift in how we address and respond to violence against women and intimate partner violence, beginning with dismantling the structural and systemic status quo in order to ensure women achieve the substantive equality for which we have long fought and to which we are entitled. We owe it to women everywhere, and they deserve no less. As we come together in support of this bill, let's not forget, and it is, as Senator Bernard pointed out, the focus of this year's 16 Days to End Violence. Let's act now. Merci.